I guess I want to ask you a bit about the preamble evidence. And I guess the question is sort of how much this shows. So I think you could imagine three positions on the preamble. One position, which tends to be the modern position, I guess you're saying maybe it's the Hamiltonian one, is that the preamble is essentially irrelevant. We just, we don't even make those arguments. And I think that is so that's one view. Then there's the ambiguity view of it, right? If the language of the Constitution is ambiguous, we look to the preamble as a statement of the purpose of the Constitution, and we resolve ambiguities and other uncertainties by reference to that. And then the third possibility is that the preamble is sort of a statement of powers on its own. And maybe necessary and proper can be used to effectuate them. And I guess the question, well, let me step back. So I think the first view that the preamble's nothing is in terms of original methods anyway, in terms of what people at the time were doing, is just wrong. And I think the evidence here is really good at showing that a lot of people, of course, did not follow that view. They cited to the preamble. I guess the question for me is between the second and the third view, right? And how much the evidence here points to the third view, that the preamble is actually a power, as opposed to just a way of reconciling ambiguities. And so some of these quotes, I'm not sure what the best interpretation of them are. And I'm not sure even how you're offering them, although sometimes it's clear. But, for example, in the Elbridge Gerry quote on page 82, it seems to me that he might very well be offering it as an ambiguity resolving provision there. I could go, he talked about the clauses of the Constitution, and they're known publicly, and they're also in the preamble. And then he says, if these weighty clauses produce the Constitution, and it, meaning the Constitution, and the Constitution not only gives power for removing them, but also authorizes Congress to make all laws necessary and proper for carrying these powers into effect, shall we listen to the assertions that these words have no meaning, and that this Constitution shall have no more energy than the old? I don't see anything in there that suggests that the preamble is a power, as much as sort of, hey, this Constitution should be had great objects in mind, and we should understand what it did in terms of the powers that are written into it broadly. So, I could go through other ones, but I've already made too long of a speech. But anyway, so I guess I'm wondering how many of these you really think support the third view as opposed to the second view.
Okay, Larry.
I profited enormously from this project now in several stages, and what I would just say, I think that this really needs to be a book. It is a topic that deserves a book, and so I'd ask for more rather than less. So three things. The first thing is that you might want to think a little bit about Morris's role in connection with sort of the standard neo-Gricean approach to the production of communicative content. So constitutional communication is a multi-stage process, but the initial drafting of the text is a crucial step in the process of constitutional communication, because it is drafting that brings meaning into being. The meaning may be altered at subsequent steps when The draft is approved by the Committee on Style. It's then passed on to the floor of the convention in a new context. It's passed from the convention simultaneously, almost simultaneously, to the public and to the Congress. That provides additional context and eliminates some of the context that was available on the floor of the convention. And then, there are further stages: ratification, implementation. But the drafter, from a neo-Gricean perspective, is the key actor in bringing meaning into being. And so I think that for that reason, Morris's role is crucially important in understanding what the meaning of the constitutional text is. Second point is about intentional ambiguity. And I think it might be helpful here to distinguish between kinds of ambiguity. I mean ambiguity in the technical sense, in which it refers to more than one sense, as opposed to vagueness or other forms of unclarity. As I see it, you have shown that Morris is introducing intentional ambiguity, but of a particular kind, not the kick the can down the road kind, right? That's one form of intentional ambiguity where there's a compromise. This is a strategic use of ambiguity to send two different messages, right? One message to sort of the next group, the floor of the convention and later on ratifications, in order to secure ratification. And another message to future officials charged either in the judicial branch or in Congress in implementing the Constitution. So this is a sort of deceptive ambiguity. And then that raises interesting normative questions for theories of constitutional interpretation. What do we do with that kind of ambiguity? And I think that those, either in a separate paper or in an expanded version of this work, deserve attention. I think that they're really important to constitutional theory. And then the third point is a more minor point. I think you tell a very convincing story about sort of the carefulness of Morris's drafting, that the Constitution is characterized by semantic precision, by an attempt to craft language that is precise as it can be, right? And that fact, and the fact that we can see this, and that the readers of Morris's draft, that is, the whole convention, the ratifying conventions can see this as well, negates a certain possible pragmatic enrichment of the constitutional text of the following sort, right? One might say, well, we look at this text in context and it's just a suggestion. It's not intended to be the kind of document that has precise meaning and that would be put into effect as a document for governance. The semantic precision here, I think, negates that inference. That doesn't mean that there couldn't be a dispute about precisely that, but it wouldn't be plausible to think that the Constitution sort of is self-negating in a certain sort of way, that it's communicating a message. Don't take me completely seriously. Instead, if there was doubt about whether the Constitution was to be taken seriously, it has to come from elsewhere. That is, in a dispute, sort of at what I would call at the stage of constitutional construction, about what we do with this text that communicates a fairly precise message, and that, because of the way it is written, suggests that it's a document intended to sort of provide law and to govern constitutional practice.
David.
I really enjoyed this paper, and my first my first comments are just a hunger for more. In particular, you might be the only one who can do this right now, and that is provide not just a list, but a well-organized list of all of the changes. I would love to see that chart. I would just eat it up for breakfast. I'm sorry, you don't owe me anything, but please. The second thing is that one of the changes made that it may be of no interest, but is of right now a lot of interest to me, and that is the choice of 7 articles. The choice of 13 for the Articles of Confederation made sense, that they divided in 13 for 13 states. And the other draft, like 23. I'm wondering if 7 doesn't have some sort of significance, that it wasn't just, well, we're done now. And it may be that it's because it's 7 of the 13 states. It's a nationalist majoritarian. I don't know. I'm just guessing. But I'm just wondering if you happen to know anything. A little bit of objection to maybe not the thesis, but the tendency, and that is to treat Morris as engaged in a kind of singular and adversarial form of constitutional drafting. That he's sneaking things in. He's acting almost in a deceptive way. Vis-a-vis the convention, or I don't want to overstate. I'm overstating it for the sake of illustration. That's not precisely how you phrase it, but the convention chose these people. They chose the committee. The draft is then submitted to a lot of relatively smart people to argue over, and then over the convention. Wouldn't it be fair to say that there may be some aspects of it that are Morrisonian, Morrisite, but that he understood himself, that they understood him to be a representative actor, agent acting on behalf of the committee, and hoping to get something that would get passed. And along these lines, one suggestion, it's a hypothesis, I don't have it, but you note the composition of the committee, and you identify it as primarily a northern committee. And I wonder if the choice of the people from the states, it does seem to line up pretty closely with how close run a thing ratification will later be in those states. So if you don't need anyone from Delaware, they're going to vote for it. We need to have someone put this together. The people that are going to put it together should be the people that may know something about the political conditions in the states to know how these things might play out. Particularly New York, Virginia, Massachusetts. Those are and a few others. The only one that's not in that list is New Hampshire. That was close. What else would I wanted to mention? Oh, just that you mentioned about the herein granted, that no one made that argument. No one in discussing enumerated powers or limited government, limited Congress, discussed the change of herein granted. What if it was just such an obvious truism that it would have been pedantic and stupid to keep? It'd be like saying, well, there are only 2 houses of Congress, and have a lengthy paragraph on it. The herein granted seems to me an obvious statement of limited legislative power, and it would have been almost insulting to constantly talk about that.
Those are all good questions. Let me I'll do it in reverse order. The committee's really, first of all, it's fascinating. The committee doesn't look like any other committee that you have at the Constitutional Convention. All the other committees at the Constitutional Convention are very well divided, between nationalists, states' rights, North, South. And it's an extraordinarily nationalist group. I think that Johnson is kind of a moderate nationalist. Other than that, you basically have, Wilson is seems to have worked on the committee, wasn't elected to it, partly because the rule was you couldn't have 2 delegates from the same state, so you couldn't have both Wilson and Governor Morris on the committee. But it's basically all of the strongest nationalist voices at the convention are on this committee, which is stunning. Again, with Johnson as the moderate nationalist. It's incredibly weighted towards the North. So all the other committees have somebody from the Deep South. There's nobody from the Deep South on this. And I think, so, what's happened is, 2 things have gone on. the states' rights people have, there are few anti-federalists, but the states' rights people have largely gone home. Hamilton comes back. He's the one person who comes back at the end is Hamilton. So just in terms of kind of the people in the room, it's a much more nationalist group. The other thing is that actually Jack has argued this, and this is right. I don't know whether he's right on the pronunciation of the name, that the way in which committees are selected by votes of the delegates, so it's not by states, and because it's cheaper for Pennsylvania and Delaware and Maryland to have people there because they don't have to travel big distance, that by the time you have the final 41, they're first of all much more nationalist, and then when the small states get the Senate, they swing dramatically. You know, we always think of the small states as being the states' rights people. They're really just self-interested. And so, you know, when you think about which of the states, you know, quickly adopts, it's the mid-Atlantic states, right? So you basically, you know, so you have this selection of like a strongly nationalist, strongly northern group, and they're selecting the committee style. You know, I do think, you know, how deceptive is Morris? I think, you know, he's famously comfortable with being deceptive. You know, the French embassy's description of him is, you know, a man without morals, and his enemies would say a man without principles. He and I think Alexander Hamilton are behind the Newburgh conspiracy to try to whip the officers up into a mutiny. So, you know, whether somebody who essentially kind of is ginning up a mutiny of the army would hesitate about crafting language that gets a goal that he wants. I mean, I think, you know, even people like Richard Brookhiser, who's written the best biography, and who doesn't think he changed the meaning, says, you know, he is, however, audacious enough to have done it, right? So I think I think he's intentionally changing the meaning. I also have to say, it's not anybody who's been involved in government. This is not that radically different from what you do with legislation. You know, you try to get language that you want in the legislation. So I think now why, you know, your other point on why it's 7, I actually don't know why it's 7. I haven't thought about that. I think the thing I focus on is that it's 3. You know, that I don't think I didn't find any of the state constitutions that are 3. And when he does that, he's both elevating the executive and the judiciary in a very striking way. So, you know, we always say, you know, what do we know about the Constitution? Well, we have 3 articles, 1, 2, and 3 for the 3 co-equal branches of government. That's his creation. On Larry's, it's, you know, actually, I deal with this more in the part that I didn't ask you to read, but is really kind of an engagement with Jonathan's book. You know, one question that I have to say, I've thought a lot about this, and it's one of the revelations for me about this is, to what extent were they, in fact, semantically careful, you know, in this time period? So my dissertation is on the origins of judicial review, and most of it's in a Stanford piece. It's about 15 years ago. It's on the judicial review cases before Marbury. What's really striking to me is how most of them are so atextual. You know, so Van Horn's Lessee versus Durrance, which is a Patterson opinion. You read that, it's not clear what clause he's talking about. I mean, seriously. I mean, you know, and then there are other ones, you know, that will read, a lot of the state cases involve the jury trial right. Like the very first case is a New Jersey case, Holmes versus Walton, involving the jury trial right. And the court rejects a statute that has a jury of 6 as opposed to 12. And all the state constitution says is there's a jury trial right. And the court says, so this is unconstitutional. They get a jury trial, right? And, you know, and they just kind of create this requirement that it's got to be 12 as opposed to 6. So I actually came into this having looked at every judicial review case before Marbury and thinking that they were not semantically careful. And I've actually written a number of articles. I wrote a piece about 10 years ago called Against Textualism. And, it was kind of critical of people, Akil in particular, but who really kind of are hypertextualists. What's interesting to me is that Morris is he's incredibly, I think, semantically careful. So he knows what he's doing. So, and I have to say, I think he's a genius. That's Hamilton and Madison used that term. To some extent, he has this vision of what the big issues are of the 1790s, and he crafts language that's relevant to them, which is amazing. But he also is working on a textual approach, which we start to see in the 1790s, but I think is really new. But again, this is something I'm really, thinking through on Larry's point. But I think, he just has a semantic care that I think is unusual. And it's partly why he's able to get this through, right? They're all exhausted. It's, they've been going on for 4 months. It's hot. They want to get home. They do this in 3 days, and they're not kind of like, oh, look at this. Madison is the one who's kind of paying the most attention. But I think generally they're not, that focused in on text. But again, that's something that I'm thinking, and I think, again, Larry, that's something I have to work through.
I would just say, if we're being hypertextualist, you weren't engaging with my book, but with my dad's.
Yes. Yeah, very good. Yes. Excellent point. So I said that before. So I refer to Jonathan's book as a book by famed historian William Gannap, who was his father.
So he was engaging with my dad's book that he never wrote.
That's right. And then on Mike's point, so first of all, you're absolutely right that I think for most originals today, it's a question of, whether the preamble is a gloss, whether it's ambiguous text or whether it's a separate grant of power. And I read I think most of the quotes that I have, I would read as a grant of power. And, we can kind of, we can fight about that. But, like the Jerry one that you focused on, the causes which produce the Constitution were an imperfect union, want of public and private justice, internal commotions, a defenseless community, neglect of the public welfare, and danger to our liberties. These are known to be the causes not only by the preamble of the Constitution, but also from our own knowledge of the history. If these weighty causes produce the Constitution, and it not only gives power for removing them, but also authorizes Congress to make all laws necessary and proper for carrying these powers into effect, shall we listen to the assertion that these words have no meaning and the Constitution shall have no more energy than the old? And that's, this is actually, I think, the best example. So if we look, and again, John has written on this, I think, very effectively, the necessary and proper clause, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. The part of there's no part of the Constitution other than the preamble that vests power in the government. In other words, all of the parts of the Constitution vest in Article 1, Article 2, Article 3. John is arguing, and I think this is right, that the preamble is the vesting in the government of the United States, and that's the argument that Jerry is making here. I think that and I think the others, Fisher Ames. Adverted to the preamble of the Constitution, which declares that it was established for the general welfare of the United States, that this vested Congress with the authority over all objects of national concern or a general nature. So I think, so I would point to those as two people who I would read as specifically talking about a grant of power. And then all the Republicans, read the Federalist as arguing for a grant of power. The preamble of the Constitution, Madison says, has produced a new mine of power, but this is the first institution he had heard of in which the preamble had been deduced for such a purpose. So that, again, that's, we can argue about the text, but those are the ones that I read as a specific grant. The one thing I just want to, on kind of the unknownness, this is, if you go to the National Archives today, and right next to the Constitution, it has a series of plates of the history of the Constitution, and it says, Governor Morris drafted the Constitution as a member of the Committee of Detail. So I've actually asked that be corrected. But I think it just indicates more broadly the way in which the Committee of Styles work is not realized or appreciated. Okay, next series.
Okay, so we have 9 more people on the queue. At the rate we're going, that will take about 3.5 weeks. We unfortunately only have about 12 minutes. So obviously we're not going to get to all 9, but I would ask everyone to please be concise in questions and answers, and we'll see what we can get through. So the next 3 is John McKyle, Andrew Kent, and Chris Green.
So, Bill, this is a terrific project. I'm very excited about what you've done here. I guess I want to try to clarify a point since my work has come up, and then offer a suggestion to you. So with respect to the preamble, I think the 3 options that Mike Rappaport outlined do not exhaust the possibilities. I think you said either it essentially means nothing, or the preamble is used to resolve ambiguities, or the preamble confers powers. And I think that's the way you describe in your paper my view. My view is actually slightly different, which is that the preamble enumerates purposes, and implicitly in the drafting of the Constitution, there's a principle which acknowledges that the government has the power to fulfill its purposes. And in interpreting that second necessary and proper clause, which explicitly refers to powers vested in the government of the United States, which I think have to be read ultimately to recognize implied powers, you then have an inference that you can draw between the preamble and the second necessary and proper clause. But that's slightly different from saying the preamble directly vests powers. It doesn't read that way. It reads as outlining the purposes or the ends, to use Marshall's term. So I'm trying to clarify an interpretation of the powers of the government that I think perfectly aligns with what Marshall says in the famous "Let the end be legitimate" passage of McCulloch. And the ends to which I think he's referring there are the ends enumerated in the preamble. So the suggestion, Bill, whether or not you are persuaded by that, but pursuing your own project here, I would really encourage you, in thinking about the Federalist Playbook, to bring in the 1790 abolition petitions. And the reason is that those petitions, and particularly the ones signed by Franklin, explicitly refer to 2 of the objects of the preamble in calling on Congress to step to the very verge of its powers and actually move to abolish slavery. So most historians read the second petition that goes in as speaking not just about the slave trade, but about domestic slavery itself. That's the way it was understood. And what you have here is a situation where, as you were pointing out, the most anti-slavery delegate of the convention enumerated the very purposes of the Constitution, which a mere 2 years later, the abolitionist societies invoke in calling upon Congress to do something that goes beyond enumerated powers and clearly is calling upon implied or unenumerated powers. I think you couldn't have a more direct connection there. And Franklin, I would include in your group of nationalists, whose objectives Morris is probably furthering in this regard. So that's just sort of one concrete suggestion. The last thing I'll say, I guess, on the preamble is I think we have to think about how the politics of how ratification transforms constitutional politics. So, Jonathan, to go to your point, it is conspicuous that Hamilton doesn't make the arguments that Hamiltonians in Congress are making when he writes a memo to Washington. Why is that? Well, there are many theories, but one thing that happened was that James Madison laid down a marker in his speech, and he said very clearly, I'm prepared to call to task things that people said in ratification and point out the hypocrisy or the duplicity, if you will, that they would now be engaged in if they turn around and argue aggressively for powers that they previously denied. Morris, of course, doesn't participate in ratification, but Wilson and Hamilton did. And I think you can see in the things that they write in the 1790s a recognition that they have to accommodate the fact that they're now on record for characterizing the government powers in a certain way. And last point, you can see this a bit in Hamilton's draft bank opinion. The Hamilton papers have both his draft opinion and the opinion that he gave to Washington. And the draft opinion goes further. And in fact, when he, for example, quotes the necessary and proper clause, he italicizes the all other powers provision that Bob is going to be talking about. But he decided not to include that in his communication to Washington. He also talks about discussion at the convention over that provision, and he pulls that out as well. So I think you can see evidence that Hamilton was differently situated in the spring of 1791 from, say, Morris when he's drafting the preamble for the Committee of Style. And I just think we can't forget that ratification in this whole period has sort of, including the slavery petitions, because that has made the preamble very politically explosive, has transformed the situation a bit, and that's, I think, why we see what we see.
Andrew.
Thanks. Like others, I think it's a great project, Bill, and really enjoyed and learned a lot from it. I don't know if you've seen on the vesting clause issue either of the two draft papers that Julian Mortensen has about the executive vesting clause. I recommend them to anyone. I think they're extremely well done. But if he's right that the vesting clause in Article 2 is just simply conveying the power to execute the law, full stop, and if that was, and if he's right that that was the generally understood meaning of executive power at the time, that it somewhat complicates a question about what Morris might have been up to in changing the language of the executive clause. I mean, in a sense, I think you can say if Julian's right, then he would be kind of smuggling in sort of a very non-standard way of referring to a suite of broader executive powers. Simply putting it in terms of executing the law, according to Julian, would just have conveyed that he can carry out laws of Congress, et cetera. So I think it'd be worth engaging with Julian's work to see what that suggests about what Morris may or may not have been up to in his word choices there.
The fugitive slave provision that they draft, they're fussing over a bunch of stuff. When they write the Missouri Compromise, they actually go back to the wording from the Northwest Ordinance. So anyone who's lawfully claimed can be lawfully reclaimed. It kind of has this nice simplicity. They go to justly and then under the laws. And in 1787, they seem kind of to be bouncing around, and Morris is involved. I wonder, is King involved? He's in Congress in 1820 when they go back to the July 1787 language from Congress. I'm also just curious, what do you know about Rufus King? Where is he on different days? Is he in Congress in New York? Is it what? Tell me more about Rufus, please.
So as I revise this, I want to do more on Rufus King. He's it's interesting. So after Morris stands alone in his denunciation. So I'm going to, again, go in reverse order. Morris stands alone in his denunciation of slavery. The only one who's second in his denunciation of slavery is King. Personally, King is actually very close to Hamilton. Hamilton actually kind of disastrously convinces King to move from Massachusetts to New York after the convention, and then he pushes King into the Senate, which actually over the Livingstons, and then the Livingstons have a vendetta against Hamilton. In some ways, Jefferson's election in 1800 is caused by a series of events that starts by Hamilton's pushing Rufus King into the Senate and alienating the Livingstons, which powerfully affects his power in New York politics and makes Aaron Burr a possibility. I don't know, I have to think about what he does in, 1820 and what he does later. He's the last Federalist, really. But he's very powerful at the convention. He talks a lot. And he's also, in some ways, the alignment between Morris and King is pretty strong. But I think I do have to look at the Northwest Ordinance. The other thing, just on the Contracts Clause, that's really fascinating is, and I talk about this in the paper, so Rufus King says, let's put the Northwest Ordinance Contracts Clause in the Constitution. Morris then speaks against it. Most historians read it as his saying, I don't think you should have a Contracts Clause in the Constitution, and then it becomes a problem about why the Committee of Style then reinserts it. So the standard view is that King and Hamilton convince Morris. What I think Morris is actually objecting to is the language of the Northwest Ordinance would actually cover statute of limitations and say you can't change statute of limitations. And I think that's what Morris is objecting to. What he then does, though, is the Northwest Ordinance says no interference with private contracts. Morris, in arguing on behalf of the Bank of North America, when the Pennsylvania Assembly wants to repeal its charter during the Articles of Confederation period, says that that would be wrong and possibly unconstitutional. So Morris thinks that you can't interfere with public contracts. And so he then takes the word out, public, out of the Northwest Ordinance language. So that's on King. John, I think that's a very good point about including the anti-slavery petitions, because they do rely on the preamble. That's a very good point, and I will do that in the future. I think that's an interesting point that Hamilton is kind of boxed in. And he can't invoke the preamble after, what he's done before in the ratification debates. But I do think we also disagree on whether, in the absence of a necessary and proper clause, the preamble would be a grant of power. So Jerry relies on the necessary and proper clause as I read it, but the others just, the preamble is just a grant of power, period. So Fisher-Ames, is really, for example, making that argument. And then Andrew, on the vesting clause, I actually saw your references to the Mortensen pieces, so I haven't read them. I think, one of the, and I will, as we're going through, I think that, the thing is, one of the big issues is all of the, what all of the branches can do is profoundly in flux, right? So, you basically have you have a very strong executive in British constitutional law, even though you don't actually have a very strong executive in British constitutional practice. The states, then, there's a variety of power that the states, give the executive, but they're pretty much all weak. The one exception is actually New York. And Morris is one of the three primary drafters of the New York Constitution. Jay is another. Jay actually has a bigger role. But I think the idea that there's any kind of accepted meaning of what the executive power is, I think is not true. And I think, again, what Morris is doing here, as in every other way, is, he's creating text that can be argued for people who agree with him. But I'll look at the Mortensen drafts to see if they cause me to shift this at all. But I saw your reference to him, and I thought that was quite interesting.
All right, well, I'm afraid we are out of time, so many apologies to those on the queue who did not get a chance to ask their question. Hopefully you can talk to Bill afterwards. Great.